Hello everybody, welcome back to Medico-Legal Dialogues. This is the 6th episode. In our last episode, Sripad and I took a deep dive into the origin of the Bolam Principle, the Bolam Fortress, how the classic 1957 UK judgment established that a doctor isn't negligent as long as they act in accordance with practice accepted as proper by a responsible body of medical professionals.
Yeah, that's right. And we have been asked with certain questions whether this Bolam actually has it been played out in the Indian courts. That is, has the Supreme Court of India and the other courts adopted Bolam as is, or have you modified it to suit Indian healthcare?
Yes, today we are answering exactly that. We are unpacking 5 landmark Indian precedents, breaking down what they mean for the doctors, patients and lawyers, and sharing various essential tips and preventive steps for the clinicians in the Bolam Principle in India. These will be the landmark precedents and various legal safeguards.
So let's start where Indian medical jurisprudence really found its footing. The basic case was Laxman Balkrishna Joshi versus Trimbak Bapu Godbole, which is a 1968 case. In this case, it involved a young patient with a fractured femur who died of shock during reduction under light anesthesia without proper resuscitation protocols. Doctor, can you just highlight what this light anesthesia or reduction of
he
light
was just
anesthesia?
given morphine instead of anesthesia, and the patient was light was in the sense he was not taken into the deep plane of anesthesia where there is no pain that is felt during the anesthesia. So this patient actually had severe pain, and because of this pain he died of shock. And this was a precursor of the Bolam case in India. The Supreme Court very clearly laid out 3 fundamental duties every doctor owes to a patient. That is, first thing is the duty of care, whether you have to take the case or not. And the second thing is duty of care in deciding what treatment to give and how to give the treatment. And the next thing is the duty of care in administering that particular treatment in a proper way as per the accepted medical standards.
So now, fast forwarding to 2005, we have the Mathew case, that is the Mathew versus State of Punjab, which came in the mid-2000s. This was the game changer where there was a distinction between civil negligence and criminal negligence. And this is arguably the most critical 3-judge bench decision on medical negligence in India. In this, an elderly cancer patient faced certain respiratory distresses, and because the oxygen cylinder connected was empty, there was a delay leading to his death. So the police registered a criminal case under section 304A of the IPC against the doctors.
Yes,
Here
the Supreme Court stepped in to formally adopt the distinction between civil negligence and criminal negligence. That is, to prosecute a doctor criminally, the negligence must be so gross or it must be so reckless that not just an error of judgment or a simple oversight is necessary. So more importantly, Mathew mandated the police cannot arrest or prosecute a doctor without first obtaining an independent medical opinion from a competent government medical board.
And I think next we have the Samira Kohli versus Dr. Prabha Manchanda case, I think, which we discussed earlier also. This related to informed consent.
Correct.
And a patient who has consented to a laparoscopic procedure who was under anesthesia at the time of performing that. The surgeon performed a radical hysterectomy. With a proxy consent, that the doctor took the consent of the mother of the patient, claiming it was in her best interest. And in this case, the court ruled that consent for a diagnostic procedure does not imply consent for major surgery unless there is an immediate life-threatening emergency, which is an exception. Right. So the decision adapted the Bolam standard to disclosure. That is, doctors must respect patient autonomy while balancing information disclosure to the socio-economic realities that is prevalent in the Indian scenario.
That's true, because we have, and this was followed up actually in the Martin D'Souza case versus Mohammed Ishfaq's case. It was in 2009 where a kidney patient was given amikacin, which is a nephrotoxic and a nototoxic.
Can you just explain that?
The nephrotoxicity is toxicity related to the kidneys. Ototoxicity is related to the ears. When this drug is given, it causes some damage to the ears as well as to the kidneys. And when this is given, the patient suffered complete hearing loss. So the court extended this Jacob Matthews case here and took all the safeguards and related to the consumers, the complaints, and etc. And it stated that the forums must seek an expert panel's opinion even before issuing a notice to a doctor.
So, though in 2010 we had this Kishan Raw's case, it clarified that expert testimony isn't mandatory in simple res ipsa loquitur cases. That is, if the thing speaks for itself. That is, for example, if there is normally we read in newspapers, there was some what is gauze or something that has been kept in the abdomen somewhere and it was not removed. So you don't require any other thing to prove it. It's already proven. So this is known as res ipsa loquitur. And Martin de Souza highlighted how cautious courts are about protecting doctors from frivolous litigation.
This actually acted as a caveat. Doctors can be litigated directly if there is a res ipsa loquitur.
True.
And if there is no res ipsa loquitur, they have to mandatorily obtain a medical opinion. Okay. This is what it stands as of now. So finally, we come to the Kusum Sharma case versus Batra Hospital in 2010. And the Supreme Court synthesized decades of legal evolution. It gave 11 comprehensive guidelines, which are very important.
So the key takeaway from this Kusum Sharma case was an error of judgment is not negligence per se.
True.
As long as the doctor acts in line with accepted medical practice, they aren't liable just because a higher degree of skill existed or a bad outcome occurred. Doctor, can you just provide the 11 guidelines?
Yeah, this is a very important thing for doctors and what they need to do, especially in this particular scenario. I'll highlight all the 11 principles one by one. Here, a doctor is negligent only if he fails to do what a careful and a reasonable doctor would have done. The second principle is a genuine mistake or a wrong judgment alone is not negligence. For a criminal punishment, the mistake must be very serious or a gross negligence.
Here, the wrong judgment means the judgment taken by the doctor at that point of time.
The error of judgment. And the third one is a doctor needs reasonable knowledge, skill and care and not perfection. Every doctor need not be perfect, but the reasonable amount of skill and care must be given. And the doctor's actions are compared with that of an ordinary competent doctor, not the best doctor in the world. So you compare it with here peers who are just ordinary doctors. And a doctor can honestly differ in their opinions. Like you are choosing one accepted treatment over another, that is not negligence. It's only a change in your protocol or the way in which you are treating that particular patient for that illness. And a treatment that carries a higher risk is not negligent because it just did not succeed. It is a known complication that this can happen and it may or succeed, it may not succeed. So that is not negligence. And if the doctor follows an accepted medical practice, he is not negligent even if another doctor chooses something different, like another different method. And the doctor's decision must be judged based on what was known at that particular time, not by looking after what happened and based on the outcome, and you cannot judge it retrospectively. And the ninth one is the doctor should not be harassed with false, unnecessary cases so that it affects the liability to treat the patients fearlessly. Most important is just like how everybody needs to be fearless in what they do, the doctors also must not be put in a psychological mental pressure or fear in their mind so that something may happen, and so the amount of output or the amount of expression in their medical
probably
would be
impacts the psyche also.
Will be hampered. Yeah. And the court cases should not be used to threaten doctors or force settlements when there is no real negligence. This very often happens, so it must be avoided. And the law must protect both the patients and honest doctors. Doctors also deserve fair treatment. The most important things are the duty, the error of judgment, the skill, the standards, the opinion that is taken by the judiciary and by the patients, the risk that is present in the accepted practices, the hindsight, various types of protections, and no harassment, and also patient welfare.
Okay, doctor, can you just give some takeaway messages?
Yeah, for doctors, the most important thing in Bolam is you don't need to guarantee a cure. You just need to act with reasonable care. One of the most important things. And for lawyers, I want you to tell the take-home message.
And for lawyers, you can't judge a doctor using hindsight bias. You must evaluate what the clinician knew and faced at the moment of treatment. So now to wrap up, I think how can doctors protect themselves in daily practice? Medical negligence litigation is rarely won or lost during trial. It's won or lost in how meticulously a clinician manages 5 daily operational pillars. That is, one is documentation, 2 is informed consent, 3 is the protocol compliance, 4th is the early consultations, and 5th is the equipment audits.
Yeah, we need to audit all the equipments that are necessary, that is to be present in a working, functioning condition before surgery or during any procedure.
And that was our complete breakdown of the Bolam precedents in India. So I think we have
taken about what Bolam is, the Bolam Fortress, and the various precedents, and what it gives a message to the doctors, the lawyers, and for the patients at large.
And I think we can next move to the Bolito Principle, which is also very important. And the court started asking in Bolito Principle, is the medical opinion not just popular but logically defensible?
Yeah, because if a doctor says something, that would have been the law, because all the doctors are correlating and then telling this is the correct method of treatment. Will the court accept it as a correct medical of treatment, or is it necessary to be logically defensible? That was what was discussed in the Bolito Principle.
So that will be being discussed in the next episodes. And if you find this episode helpful, don't forget to like, share, and subscribe. And drop your questions or cases in the comments below. So we'll see you in the next dialogue. Thank you.
See you again. Thank you very much.